Appeal number 134, People versus Alexis Ocasio.
Counsel? May it please the court, Mary Ann Stracadano for the people. I'd like to request 2 minutes of rebuttal time.
Certainly.
Your Honors, the accusatory instrument in this case was facially sufficient and should not have been dismissed. As the previous case noted, the same goes for this case, that all that was required here was that the accusatory instrument alleged facts of an evidentiary nature supporting the charges, and that those facts provided reasonable cause to believe that the defendant was guilty of the crime charged, and that the non-hearsay allegations establish each element of the crime.
How do you define a billy?
So a billy is a police baton, a billy is a nightstick. All of these terms in common parlance mean the same thing. Looking at the patrol guide, it's clear that this type of expandable baton is given the same is interchangeable with the idea of the wooden baton that
Well, you agree when this statute was put in place, police batons were wooden,
correct.
right?
Yes.
Okay. So, so what if, so does that, so I guess what is it that defines it as a even if we say it's a police baton, what is it that defines it as such? And how would the average person know? So at one point you had a baton of a certain length and it was made of wood and that was that. Okay, now we're talking about something that is extendable. Okay, so it starts as one size, it becomes another, and it's not made of wood. How do we know how does the average person know that is a police baton or a billy club?
So the concept of the billy club is a plastic, it's a fluid concept, and we know that, this particular type of expandable baton is one that only police officers use. It's not even for sale, in common marketplaces. It's mostly for sale in like police supply stores or,
So would it be a different, when I was younger, I used to twirl, batons in the dancing band or whatever. Would that qualify? Could that qualify as what we're talking about, that similar to what the police use?
No, I think that the third department's decision in Shoemaker could be persuasive here, because certainly the purpose for which this particular type of expandable baton was designed was for law enforcement purposes, to subdue a suspect in order to, effectuate an arrest.
So, counsel, are you suggesting that when the police department determines to update the equipment that is issued to a police officer, and instead of using the old traditional billy, the wooden billy, they move to an extendable baton, that stretches the definition under 26501 to accommodate that? Is that what your argument is?
Well, I don't know if it's precisely the NYPD itself that stretches the definition. I just think that the essence of the billy club is a police baton. Nobody says billy.
So who defines police baton? Is it the police department in their determination of what equipment they issue to their members?
Partially.
And that the interpretation of the statute tracks their determination of what a new billy is?
Partially, but also there is in the 26520 section, there is, the legislature did say that for the billy that is also known as a police baton. So that's there in the statute.
Did it reference
itself.
to the potential to expand, that it's expandable?
That section does not say that it's expandable, but
And historically, these were not expandable, right?
over the last 20 years.
No, but historically,
well,
going back in time.
Going back in time, and at the time that Talbert, which is the third department case that the appellate term rested its decision on in this case. At that time, yes, police batons were wooden. However, the concept of a billy is a malleable concept.
But I guess I'm saying, if I may, when the legislature seeks to clarify a provision, and as you point out, passes 265.20B, would it not at that point have had the opportunity, if it chose to say more than just a police baton, which is within a certain length and within a certain thickness? Would the legislature not at that point have said expandable, if it wanted to say that, or metal, if it wanted to say that?
It could have, however, it doesn't
Well,
foreclose.
doesn't that tell us something that they did not when they had an opportunity to do, I think, exactly what you're suggesting, which is to clarify that billy can have many meanings and still fall within the statute?
That cuts the opposite way as well. I mean, the fact that they didn't strictly define, amend the 265.00 section in the
So
definition.
you're asking us then to say that billy falls into a generic term like a bat, like a baseball bat. In other
Yes.
words, a baseball bat, when I played baseball, was a wooden bat. Now that I take my nephews, they're aluminum or graphites, but they're still bats.
Correct.
They're still called bats. And the definition hasn't changed. Another similarity would be clubs, like golf clubs. Golf clubs at one time were all made out of wood, and over time they become aluminum and other things. And that you're saying that this term falls, billy is a term of art in that sense, rather than a definitional term with the exactitude that the defendant is seeking.
Exactly, Your Honor.
But
This
counsel,
As Judge Garcia would say, that's a softball.
all this discussion in that these are fluid, I think you said, and malleable concept, it comes back to me, though, that this is a strict liability offense, right? So the definition is the crime, so to speak, right? So in that case, we have to be very careful as to what falls within that definition. So while this might, in a baseball bat connotation, but in a strict liability weapons connotation, a baton, there's really no other legitimate use for it, right? Agree. But that isn't really answer the question of whether it falls within one of the specific weapons that are listed within the statute. And the fact that it's, that it can be fluid or it can be malleable, doesn't that cut against us reading more things, reading it that way? Because really, for a strict liability offense where somebody who possesses is guilty of a crime, wouldn't we err on the other side?
Well, statutes should be construed to effectuate the legislature's intent as technologies evolve, and this is the type of, this expandable baton is a billy club for all intents and purposes because it is what the police are using in their law enforcement purpose. And we know that the legislature doesn't want this in the hands of untrained, ordinary civilians.
But I think then, isn't the legislature in the best position, which they have done before, to assess the technological advances and make a specific item on that scale a per se weapon?
It just doesn't have to because of this malleable concept.
Doesn't the rule of lenity require an affirmance here? If you've got two possible constructions, don't we have to take the one that is the most narrow in this case?
No, Your Honor. All throughout the legislation, the litigation below, we argued that this was a billy under the statute. It is inclusive of this type of baton because of the purpose for which it was designed. I see my time is
Thank you,
up.
counsel.
Thanks.
Counsel?
Counsel, when we were just talking about the legislature and what it did or didn't do, when it came to metal knuckles, it defined them as metal, right? And then when plastic knuckles came along, it had to add a new thing because it was very specific. Here, the legislature just called it a billy. It didn't say a wooden billy. It didn't say, it didn't describe it at all. So is there a difference there? Can we draw any different inferences there?
Good afternoon, may it please the court. Paul Patterson of Paul Weiss for the respondent. And to answer Your Honour's question, I think that is an incredibly good example of how we are dealing with a statute which is very specific and very specifically prescribes possession of objects based on their physical characteristics. So to take that example, metal knuckles...
This one doesn't, right? This one has no description
Well,
at all.
billies were wooden. Billies were heavy wooden
What are-
clubs in
what are
1866,
baseball bats?
Your Honour. Baseball bats are wooden as well, Your Honour.
Are they? Okay.
Yes, Your Honor.
So anything that's, that looks like a baseball bat that is being used in a baseball game that's not wooden, that batter is using something other than a baseball bat.
Well, Your Honour, the way the third department dealt with this issue in the Talbot case is to say that a billy is a heavy wooden stick, which from its appearance...
So you're saying, yes, that's right. The batter may think he's got a baseball bat, but he doesn't. He has something else.
I'm saying he doesn't have a billy, Your Honour.
I
And the reason-
understand your point, but my point is exactly the opposite. And there's a billy, and as your opponent is arguing, billies have moved on. And when you have an officer who says that, that he describes the item, he says that based on my training and experience, which includes training in the recognition of weapons, that the aforesaid metal baton is a bludgeon, and that the deponent says, the defendant said, I took speed cuff training at a class, I bought this from the police. How much more information do you need to know that this is a billy club?
Your Honour, because it does not have the defining characteristic of being a billy
You're
club.
saying it defines something perfectly, but this does not fit within the statute.
I'm saying it does not fit within the statute,
So
Your
any and
Honour.
all defendants who may or may not have one of these things is walking around town and they're perfectly legal and they can beat people over the head with them, and that's not a dangerous weapon.
No, they cannot, Your Honour, because 265012 prohibits possession of any dangerous or deadly instrument, provided you have intent to use it unlawfully against another. We're dealing with a very specific statute which only prescribes specific items, and it does not prescribe possession of every item that can be a dangerous
Well,
weapon.
what if it was a wooden item, as you say a billy has to be, but it was capable of being folded in half for storage? Would that be a billy?
Well, Your Honour, what several courts have said is because the defining characteristic of a billy
Is that a no?
is it would not be a billy because it's not a club. It's not a club, Your Honour. It's
So,
a
what do
different
we
instrument.
make of Penal Law Section 26520, where it appears that the legislature is saying that a billy is equivalent to a baton?
Your Honour, I think 26520 actually says exactly the opposite. Because what 26520 says is that auxiliary police can possess, quote, that type of billy commonly known as a police baton, provided it met certain characteristics. So it regards billies and police batons as different items. Under the people's interpretation, that section would read that type of billy,
Your
i.e.
client,
police baton,
client
commonly
said
known
that
as a
he got it from the police.
Your Honour,
There is little doubt, unless you tell me something different, that this is a police officers' club that, as your opponent is arguing, is an advance on the wooden baton billy clubs. And what you're saying is, well, then they should have amended the statute. We admit we've got what's the equivalent of a billy club here, but because they didn't change the definition in the statute, we are okay.
Your Honour, just as a
Right.
preliminary point, I don't know anywhere in the record that references my client as getting that from the police. I think that may be a reference to the Lopresti case, which is a different matter.
Opponent further states the defendant stated in sum and substance, I have it for protection. I took ASP and speed cuff training at a class. I bought it at a police store.
Your Honour, because the defining characteristic of a billy is not whether or not it's a police baton, I respectfully submit it's simply not relevant whether or not it came from the police. And I also submit defining it as a police baton would be both under-inclusive and over-inclusive. It's under-inclusive because not every billy is a police baton. The third department in the Talbot case considered an item that was a homemade broom handle with tape wrapped around each end, and the third department held that the police had probable cause to believe that that item was a billy, even though it's not a police baton.
Do you agree with that decision?
Yes, I do, Your Honour.
Okay.
But doesn't that decision cut a little bit against you here? Because you focus on the fact that it's a heavy wooden stick, which they do say. But it seems to me the real thrust of that Talbot decision is with a handle grip, which from its appearance is designed to be used to strike an individual and not for other lawful purposes. So if you take the wooden out of that sentence, a heavy stick with a handle grip used to strike, that's what you have here. I mean, that's this.
But
So
I think-
you're saying just because it's metal and not wooden, it doesn't meet this definition?
It's a two-part definition, Your Honour. It has to be a heavy wooden stick under Talbot, and from its
Why?
appearance. Because that's what a billy always has been, Your Honour, and that's what a billy is now. We simply don't see, and the people have not identified
You
any
understand the
reference.
problem with that logic, though, is the law can't be that static. I think there was a good point made, I'm not sure which of my colleagues made it, about it being a strict liability offense. I thought that was a good point, but the problem is most weapons offenses that we deal with involve guns, involve strict definitions, strict liability, and it seems to me that it can't be totally, that we're not necessarily stuck with an 1862 picture of what a billy is, and that's it, because that's impossible. The law has to be more malleable, more flexible than that. Otherwise, you can't enforce it, you can't protect people, you can't protect either their rights or their responsibilities. You create an impossible situation for us that way.
But, Your Honour, the statute doesn't say police baton. I agree with you that if it said police baton, it would be broad enough to capture items that are then used as police batons. It says billy, which is an incredibly specific item.
But is this, I mean, your argument is if these instruments, similar to the one that you got that was bought at the police store, is being used by police officers throughout the city, you can safely say there isn't a single police officer in this city that has a billy.
I don't think, that it may not be, Your Honour, if they're not carrying around heavy wooden
Wouldn't that
clubs.
surprise them?
I don't think so, Your Honour.
Okay.
I mean, it may or may not, but they don't have billies. And in fact, if you look at the patrol guide, the people talk about the patrol guide. The patrol guide doesn't talk about billies because no one uses the term billy in ordinary language to talk about an extendable baton. I mean, we cite numerous articles in our brief, recent articles, talking about billies as being obsolete items that are hanging in
The funny thing
museums.
is that the word itself, the etymology of the words and now these things are called asps, and that's because that's the name of the manufacturer that makes them now. And I imagine billy has a similar kind of William reference back in its etymology to why it became called that particular kind of stick. But there's nothing in that word that connotes a wooden stick.
There's nothing in the word, but it's in the meaning, Your Honour. It's always been in the meaning. There was no need to add wooden billy. And to go back to Judge Stein's point from before about metal knuckles, we do have a section in the statute that specifically prohibits possession of metal knuckles. I think that was because at the time, wooden knuckles were also in existence. And actually that just shows just how specific the statute is, because the legislature...
But my point is when the legislature wanted to focus on a specific item, it did. When this legislature wanted to make it a more broad concept, and when it says in 265-20 that it refers to a type of billy commonly known as a police baton, to me what it's saying is that a billy, that a police baton is a billy, but there are other types of billies that aren't police. And so it was a more flexible concept that the legislature intended to prohibit here.
I think 265-20 says both, Your Honour, and that there are types of billies that are not police batons, and there can be types of police batons that are not billies, like extendable batons, which are just not referenced in ordinary language as billies.
Well,
And I don't think...
actually, 265-20B describes the police baton. It doesn't just say police baton. It has particular length,
it
it has
does.
particular thickness, so it is not accurate to say that in that section, it's more, a type of billy is a police baton. It's defining and describing a particular police baton.
It is in the type of police baton that it describes. Everyone agrees is the traditional wooden billy that has been in
But
existence.
does it say wooden anywhere?
Well,
in
the physical
265-20?
characteristics it gives, the 24 to 26 inches in length and the thickness, I think the people agree in their brief, and we agree as well, that's describing a traditional billy. So all it's regarding and saying when that provision was enacted is that a traditional billy was used as a police baton. And Judge Stein, to go back to your question, I don't think it's true that in 265011, any time that a material defined the item, so for example, metal knuckles, the material was listed first. So for example, we have a blackjack that's also listed in that section, also used as a police club. The defining characteristic of a blackjack is that it's leather. Likewise, we have a sand club that was added at the same time as billy was in 1866. And the defining characteristic of a sand club is that it's made of sand. So there are all sorts of objects that are listed in this incredibly narrow section that are defined based on their physical characteristics, just like a billy club is, Your Honour. I see my time is up, so unless the court has any further questions, I'll rest on our papers.
Thank you, sir. Counsel?
I I just wanted to emphasize that ultimately, like the previous case, the question of whether or not this baton constituted a billy was one that the jury could have answered, one that the trier of fact could have found. The allegation that it was a billy because it had a rubber gripped handle and the fact that it was expandable was sufficient for pleading purposes. And unless your honors have
Well,
any.
I'm sorry, so how would the judge explain Billy to the jury?
Well,
What would he or she say?
I think that what would happen is at trial, the people would present their witnesses who would say, this is the type, I'm a police officer, I have this type of police baton, this is a billy, and then the defense could have
A
whatever.
police baton, and that's Billy. So it's
Yes.
all Billies
Yes,
are police batons, and all police batons are Billies. Is that your position?
yes. I
So
think
then
that
why
billy-
is 265.20B written as, there is a type of Billy, commonly known as? Doesn't that suggest that there is not the complete overlap that you are arguing?
I think perhaps at the time that that section was amended, again, there is question about what was the actual common makeup of specific police batons. But
Baton or Billy? His argument is that this is describing some typical characteristic of Billy.
I think that but a billy is never used in common parlance outside of the scope of referring to a police baton. So that section does refer to specifically the police baton because it states the length and the width in that sub 20 section. Also, I mean, that section has to do with auxiliary police officers. That's another added.
So if cops use spring whips, that's Billy?
I think certain spring whips could be, I thought about this, Your Honor. I think certain spring whips could be billies, but
Cops used a spring whip that had metal spikes at the end, is it a Billy?
I think then we start to,
What is the difference then? What makes the difference?
the difference is whether or not it is a club-like thing that opens, right, well, in my case, that it opens, it becomes a club-like thing that can be used in order to subdue a suspect when a police
Aren't my
officer.
examples that, the spring whip, the object that at the end has the spikes? Haven't you just described that?
I feel like a spike is a different, I would not purport, spikes have a different essence than just a stick that is basically being used to so.
Thank you, counsel.
Thank you, Your Honors.